warranties, okay? Uh, there are basically two types of warranty, express warranties and implied warranties, okay? Express warranties are somebody gives you a guarantee. They put it down in writing and say that I fixed the brakes on your car. If the brakes should go out within the next 90 days, you can bring it back and I'll fix it for free. That's an express warranty. They're guaranteeing you that they'll take care of your car, even if it breaks down again under that 90-day warranty or 60-day warranty. My wife and I had our washing machine repaired, and the guy came out and repaired it. And a couple of weeks later, it went out again. And he came back and fixed it again for free because he had warranted or guaranteed his work for like 60 days. So anyway, he came back and fixed it. So there's an implied warranty. An implied warranty simply says, in essence, a toaster is going to toast. If you take a toaster home and it's not toasting, then that's a breach of the implied warranty. A chair, it's implied that a chair is going to hold your weight. They don't have to give you an express warranty for that. It's implied. A television is going to play programs. Certain things are implied warranties. They come with the warranty. There's a warranty of title. Generally, when somebody's transferring something to you, they have ownership and they're warranting that they do own what they're selling to you. If they don't have title, you can sue them for breach of warranty of title. A warranty of merchantability. Warranty of merchantability says essentially that whatever you buy is merchantable. You know what I'm saying? Again, going back to the toaster is going to toast. It's going to work. A radio is going to play music as you turn to the different stations. So there's a warranty of merchantability that the thing is going to do what it says it's going to do. And warranty of trade usage is simply, those bubble wraps that a lot of times you get a package, you open up the package, those little bubble wraps come in to protect, or they have cotton to protect aspirins. And that's the trade usage. So in other words, you get some aspirins without any cotton in, and all your aspirins are broken to pieces because there was no cotton to hold the aspirins in place. That would be the breach of the warranty of trade usage, because most industries use bubble wrap or cotton to package stuff. And if you get your stuff sent to you without that, then you could argue that they violate the warranty of trade usage. Some of the defenses to warranties are waiver. You can waive the right to a warranty. You can sit up here and the person can sit up here and say, I don't want to give you a warranty on this particular product. I don't want to give you a warranty on this particular repair. You can waive the right to a warranty. Also, you can sell the product to a person as is and say there is no warranty on this particular product. Or you can disclaim it. You can disclaim a warranty. In other words, I'm not giving you a warranty. Another defense is a buyer's misuse of a product. For example, if I sit in a chair, that's the implied warranty of fitness, or implied warranty of fitness for a particular use. I didn't put that up there, but implied warranty for fitness for a particular use. In other words, this chair is for sitting. And it's also foreseeable that I may stand in this chair to nail something on a wall. That's foreseeable too, going back to torts. But what's not foreseeable is that I would jump on this chair and ride it like a horse. That would be buyer's misuse of the product. So if you misuse the product, they don't have to honor their warranty. The statute of limitation is another defense. If the statute of limitation, if you don't sue in time, then the statute of limitation can run out. If they tell you you have a year to sue us and you don't sue within a year, then that's a major defense to you suing. Sometimes the contractual limitation, they'll sit up here and say, you must notify us within 60 days if there's any defects. And if you don't notify them within those 60 days, they can sit up there and say, hey, we're not going to honor the warranty because you didn't notify us within the time frame. And then insufficient notice, again, going back to the limitations. Insufficient notice is you didn't give them enough time in which to put them on notice that there was a problem with the product. So the contract itself can limit liability too. You and the other party can agree to limit liability. Do you guys have any questions? Parole evidence rule, that simply says the four corners of the contract are the evidence of the contract. You can't use oral terms outside of the contract to contradict the written terms of a contract. If you ever seen that movie about McDonald's, the guy that bought McDonald's from the McDonald brothers, Crouch, he told them, hey, let's make a side deal and I'll pay you royalties for the rest of your life. And he said, I don't want to put it in the written contract, but we can shake hands on that. Well, since it was never put in the written contract, he didn't have to honor it. So he tricked those brothers out of their McDonald franchises and basically lied to them. He never did pay them anything. I think he gave him a couple of millions for McDonald's and he turned it into $1 billion corporation. But the parole evidence rules say you can't introduce oral terms that contradict what the written terms said. And there was nothing in the written terms about giving them royalties. It was outside of the four corners of the contract. So the parole evidence rule says you can't use it to contradict the terms of a written contract. So remember that. If somebody's talking to you about, hey, I got a deal with you, I want to shake hands on it, but I don't want to put it in the contract. You tell them, hey, I want it in the contract. Does anybody have any questions? Okay, let's stop looking at that one. Let's look at another one. Okay, can you guys see this new one about principal agents?
Yeah, we could see it.
Okay, a principal is basically a person that's in charge. The principal is the owner. Like the Lakers have an agent. That agent goes and negotiates with people like LeBron James, Luka, and he's the agent for the Lakers. The Lakers are the principal, he's the agent. Generally, when you buy a house, you're the principal because you're asking the agent to go purchase a house for you, or you're asking the agent to sell your house for you. So the principal is generally the owner. The agent works for the principal. There are several types of agents. There's a disclosed agent, there's an undisclosed agent, and then there's a partially disclosed agent. A lot of times, if Beyonce is going to buy a house, she doesn't come to the area herself. She sends an agent. Now, that agent can sit up there and say, I represent Beyonce. That would be a disclosed agent. Or he cannot tell them who he represents. That would be an undisclosed agent. Or he can be a partially disclosed agent. He can say, I represent somebody, but I can't reveal their name. Okay. And then your book talks about how agencies are terminated. You have to give actual notice. The principal tells the agent, I no longer need your service. Constructive notice is basically you publish it in a newspaper. and say, I don't want to use your services anymore. When the purpose is fulfilled, like when your attorney represents you. Attorney is an agent. You're the client, but you're also the person in charge. So you can tell the attorney, you won my case. My purpose for hiring you has been fulfilled. I don't need you anymore. Lapse of time. You can say somebody's my agent for 30 days, for 6 months, for 2 years. Sometimes people who are facing dementia will have one of their kids become their agent to sign their checks. If they do that, they should get what's called a durable power of attorney. A durable power of attorney. And the beauty of a durable power of attorney, in contrast to versus a regular power of attorney, is a power of attorney only lasts until a person is disabled. Whereas if you get a durable power of attorney, it will even outlast disability. It won't outlast death. Once you die, the power of attorney cease. But get a durable power of attorney, so if that person later on does get dementia, you can continue to sign checks and put checks in their bank account and negotiate deals for them. A durable power of attorney is cheap, not expensive. If you wait till they get dementia, you wait till they're not in their right mind, you're going to have to get what's called a conservatorship. And a conservatorship can cost anywhere from $10,000 to $15,000. So it's better to get a durable power of attorney. If you see your parents are in decline, the principal can revoke the agency relationship. Say, hey, I don't want you to be my agent anymore, and revoke and take back. The agent can renounce the agency or the occurrence of a specific event. You sit up here and say, I want you to be my agent to negotiate a deal with Sony for a certain amount of television. And after that, the agency is terminated. But it's the occurrence of a specific event, and then the agency is terminated. So remember that durable power of attorney versus just a power of attorney. Durable power of attorney survives disability. Does anybody have any questions? Anybody have any comments? All right. Well, I was explaining to the students that if you own property, you're the mortgagor. The bank is the mortgagee. And you're paying money to the bank. They don't own the house. They can always foreclose on you if you don't make your payments. But they basically have a lien against your house. You're still the owner of the house. If you weren't the owner, you wouldn't be able to go get other loans. So you are the owner. The bank is just the mortgagee. I also told the students that the Dodgers are the principal and they have an agent. And their agent represents them. Showed you guys that. Oh, remember, we had a break November 24th to the 28th. And I was telling the students the difference between UCC and common law contracts. UCC contracts, the price is left open. Common law, you need definite and certain terms. You can't leave it open. UCC contracts, the payment can be open. You don't have to write it down. You can negotiate it later. Whereas in common law, you have to have definite and certain terms. The time for execution is open in a UCC contract. In a common law contract, you have to put down the time. The duration is reasonable in a UCC contract. In a common law contract, you had to have definite and certain terms. Now, here's where UCC and common law are the same. When it comes to quantity, you cannot leave the quantity open. So you and I can agree that I'm going to buy 50 motorcycles from you. But we have to put down the word 50 motorcycles. The rest of the terms under UCC can be put in later. The price, the payment, the time, the duration, all that can be put in later. Whereas with common law, you have to put it in now. If you don't, the contract fails under common law. Also, there's an exception under the UCC that is exception to the statute of fraud. Statute of fraud says certain contracts must be in writing. But if one merchant sends a writing or a note confirming an oral agreement to another merchant, and that other merchant doesn't object within 10 days, then it is deemed an accepted contract in spite of the statute of frauds. So basically what they're saying is one merchant will send an invoice to you, to another merchant, and say this will confirm our oral agreement. And the other merchant that was sent the invoice or the memo doesn't object within 10 days, then the law says that note becomes an exception to the statute of frauds. Does anybody have any questions? Really talked about that. What was this? Oh, I was telling the students, when you're negotiating with people, always negotiate from the top. In other words, make your demands high. You're on the top of the roof because the other party is going to make their offers low. They're going to start from the floor. And so we did an exercise in class where the Dodgers had a contract for Ohtani. And the first offer was Ohtani demanded $100 million for 10 years. And then Ohtani came down to 90 million for 10 years. Then he came down to 95. In the meantime, the Dodgers offered only 80 million. This is just hypothetical. Then they came up to 90 million in 11 years. Then they came up to 93.5, 93 for 11 years. And then finally, they agreed on a contract for 94 million. For 94 million, I think it was. They finally agreed. No, let me see. No, here. No, they finally agreed to a contract for 93 million for 11 years. But you got to try to bring the other person down. And then the other person is trying to bring you up. And you reach a compromise, and that's what you accept. I was trying to teach the students how to always start high in your demands. Okay. And then I was showing the students how you look up a case number. Miranda versus Arizona, for example, the address for that case is volume 384 of the US, page 436. And it's 1966, Miranda versus Arizona. That's where you would find that book. And I was telling them the book number is generally in front. Specific second means it's on a West Coast case, second series, and it's on page 752. That's another case. If the case is on the East Coast, a lot of times it's Atlantic. You have the number in front of AD, and you have the page number behind. I was trying to show them how to look up cases. And some cases are on the Northwest, some cases are on the Southwest. But every case in the United States has an address. And this is how you find cases. I was telling them also, there's so much law today that attorneys are specializing. I said, when Abraham Lincoln was alive, you probably found the law all together in about 16 books. Now there's so much law that a family law attorney doesn't practice criminal law, or criminal law doesn't practice family law, or a tax lawyer doesn't practice these other areas of the law. They generally specialize in that one area because the law is so voluminous. It's so much law today. In fact, there's rumor that Mike Tyson had his tax lawyer do his rape case. And that's why he lost, because his tax lawyer wasn't a criminal lawyer. I don't know how true that is, but that's what I was told. Okay. So we went over that. And then we went over a case. Let's go over this case with you guys. Professor James ordered 1,000 roses from Amazon for his wife on Valentine's Day. Amazon promised to deliver the 1,000 roses by UPS to his address. What type of contractual relationship exists between Amazon and UPS? Can anybody answer that?
Yeah, it's like the third party delegated third party contract or something like that. It was
Very good.
yeah,
Ileana,
delegation
very
of
good.
duty.
Very good. Very good. That's exactly what it is. And if you don't know, you can make a diagram. You can make a diagram. Here you go. I'm Professor James. I'm where the P is. Let me bring the arrow over here. Okay, I'm right here. Is my arrow working? Okay, anyway. Professor James P makes a contract with Amazon. We have a contract. And then Amazon and UPS have a delegation contract. They're delegating the duty to perform to UPS. Now, what kind of contract is it between me and Amazon? Anybody? Malik? Angel? What kind of contract is that between?
Is it like promisee and promisor type?
Yeah. But what type of contract? Is it common law or UCC?
Oh, UCC, because yeah, it's a merchant to consumer.
Very good. Very good. Merchant to consumer. The rest of you guys see that? Another student spotted the perfect tender rule. Said it has to be done in pursuant to perfect tender rule. This is an exam that was on a test previously. So I told students to take a picture of it. You never know. It may be on another exam. Then it says, what type of contract exists between Professor James and Amazon? Well, Ileana already answered that. Delegation contract. Now, what is the contractual term called when Professor James received the 1,000 flowers for his wife? What is that called? Angel, what is that called?
I actually don't know.
It's called a discharge. It means the contract has been discharged or the contract has been executed. When the contract is formed, it's called an executory contract. When it's completed, it's called executed or discharge. When each party has done what they're supposed to do, I've paid my money, they've sent my flowers, everybody's done what they're supposed to do. It's called executed. Okay? All right. I already went over that one. We already went over that one. Okay, here we go. Here's another one we went over. This is earlier. Mary pays $50 a month for a $100,000 life insurance policy. The beneficiary is Daniel. Daniel gives the right to the $100,000 policy to Laura. Laura gives the $100,000 policy to Lewis. And Lewis gives up his rights to the policy to Diana. Who owns the policy? Malik, who owns the policy? First of all, what type of contractual relationship exists? Angel, Malik, Ileana, what type of contractual relationship is this?
This is. Oh, go ahead. If somebody else knows the answer, go ahead.
Okay.
I was gonna say ownership. What is it called? Beneficiary.
Okay, but that's close. But what is it called? What's the actual name? That's close, but that's not exactly on point. What is it called?
It's the third party beneficiary donee contract.
Very good. Third party. Remember that, Angel. Third party beneficiary donee contract. Third party beneficiary donee contract. Okay, so now the question becomes, who owns it if it's a third party? Who are the three parties? Mary, the life insurance company, and Daniel. Daniel is the third party donee.
Is it Diana?
Why is it Diana? That's the correct answer, Angel. That's the correct answer, but why? So if you put on your paper, Diana, I'm not going to give you full credit because you haven't told me why. Why is Diana now the owner of the policy? By the way, that's the correct answer, but why?
Because the ownership was validly transferred to her and any beneficiary, kind of.
No, that's not a real. You're in the right arena, but you're not explaining it correctly. Ileana, can you explain this?
Well, Diana succeeded the beneficiary donee policy, so because therefore Daniel gave up his rights to being the beneficiary. So okay. Laura succeeded Daniel, and then
what do we call that?
I don't know the correct. Is it vesting?
No, it's called an assignment. What you have here is both a third-party beneficiary contract, donee contract, with an assignment. So in other words, Daniel is now the owner of the policy, third-party donee beneficiary contract. He assigned his rights to, who was it? Laura. He assigned it to Laura. So he's an assignor. Laura is the assignee. Laura then gave the policy to Lewis. Laura is now the assignor. Lewis is now the assignee. Lewis assigned it to Diana, and Diana is now the assignee. Lewis is now the assigner. So Diana owns the policy. So it has both a third party donee beneficiary set up, but it also has an assignment set up. This was a previous exam. So you guys make sure you study this one, okay? It may be on your final exam. Okay.
So if you're asking, like, say for example on the final, who owns the policy, we have to both notate that it's Diana and then explain why.
Yeah, you got to explain. It says, what type of contract exists in this fact pattern? It said, who owns the policy? So you'd have to say Diana. And then you have to explain what type of contract exists in this fact pattern. So you'd have to explain what's a third party donee beneficiary contract. Name who the parties are.
Got it. Okay.
And then you would have to say also enclosed in the fact pattern is an assignment. And say Daniel is the assigner. He assigned his rights to receive that money to Laura. Laura in turn assigned her right to receive it to Lewis. Are you hearing this, Malik? Malik, are you hearing this? Malik, are you there? Malik. Okay. Do you understand, Angel?
Yeah, I understand it more after you explained it.
Okay, so remember that. You can have a third party also with an assignment. Assignment is also a third party. The difference between assignments and delegation is the contract is formed first, and then the delegation occurs afterwards, or the assignment occurs after the contract is formed. Whereas with a third party donee beneficiary contract and a third party creditor beneficiary contract, at the time the two parties enter into the contract, they enter into the contract for the benefit of the donee or for the benefit of the creditor, the third party creditor or the third party donee. Whereas assignments and delegations occur after the contract is formed. Okay? All right? Remember that for your final exam. By the way, we'll have a class next Thursday, which is the 4th. This Thursday, I'm sorry. And then we'll come back together. We'll have a class on the 9th, which is next Tuesday. And then we'll have a class on that Thursday, which is December the 11th. And at that class, we'll have a review of old exams. And then I won't see you guys anymore. You'll take your final exam the following Thursday. There will be no more classes after the 11th. Okay? Does anybody have any questions?
Is the final kind of like the same? It's due at midnight?
Yes. Oh, here's another exam question that I gave the students. This is the last one I'm gonna give you, okay? Karen is an agent for Richard. Richard ordered Karen to buy 40 acres of land. Karen bought the land for $20,000, but told Richard she paid $40,000 and kept the difference. Okay? For herself. Now, my question to you is, what type of contract is this? Was a contract formed? And was the contract breach? What would you guys say?
Did it state that Richard accepted it? I'm sorry, I'm not able to see.
Okay, Karen is an agent for Richard. My students in the class said Karen is the agent Richard is the principal. He's the owner. Karen is his agent. So they said it's a principal agency relationship there exists here. Richard ordered Karen to buy 40 acres of land. Shouldn't be A. Should be to buy 40 acres of land. Karen bought the land for $20,000. This is the second contract. But told Richard she paid $40,000 and kept the difference for herself. So the student said it was a contract, two contracts. There was a breach of duty. There was a breach of fiduciary duty of trust. The student said in all contracts in California, there's an implied covenant of good faith and fair dealing. So in all contracts in California, the legislature has said it's implied in all contracts, whether you have written it down or not. All contracts have an implied covenant of good faith and fair dealing. I was telling them in an insurance company, you're a first party insured. If your insurance company treats you in bad faith, you can sue them for millions of dollars. If your insurance company takes forever to process your claim or forever to treat you in resolving your issues in a reasonable fashion, you can sue them for bad faith and get millions of dollars. And I told the students, and then later on, they start bringing up other types of issues. And I told them, first of all, you got to ask yourself, was a contract formed? Was the contract breach? What are the defenses? What are the damages? Do we go to a court of law or a court of equity? I was telling them about this guy. He was a tax man for this lady, older lady, about 85 years old. And he introduced her to one of his friends. Well, his friend swindled the lady for millions of dollars. The lady was very rich. And so the lawyer didn't sue the swindler. He sued the tax man that introduced the old lady to the swindler. He said that he had a fiduciary duty of trust and that he breached that fiduciary duty of trust by introducing that old lady to a person who was going to take all her money. And he won. He won. So fiduciary duty of trust is the highest trust you can have. You know, in other words, if I send you to buy land for me and you usurp the land for yourself, I can get you for breach of duty because you're using the opportunity that I presented to you to make yourself rich. And you have a duty, the highest level of duty is a fiduciary duty of trust because I'm trusting you with private information, my social security number, my tax, my bank account number. You know, you have to treat me in good faith because you know so much about me. Another student said we could have sued for fraud. Karen could have been sued for fraud. And we talked about Eddie Murphy's ex-wife. She wrote a check to a guy for something like $10 or $20 million and never saw the guy again. You know, so you got to be careful when it comes to money. You know, I had a student in my classroom get up and do a vision board one time. And he said, money doesn't matter to me. I don't care about money at all. And I said, do you have any money in your pocket? He said, yeah. I said, well, why don't you let me have it? You know, he said money was evil. And I said, well, why don't you let me have your money? Because I'd hate to have you carrying around evil. But anyway, to make a long story short, be wise when it comes to your money. Okay? Be wise.
I had a question.
Yeah.
Just to make sure I'm grasping my understanding. So this contract would be considered an agent principal or principal agent contract.
Yeah, it would be a regular contract. It's involving land, so it would be a common law contract involving a principal and an agent. And it says that Karen is an agent. And that's your clue that Richard must be the principal.
Got it. So like when I'm responding to this type of question, I say this is a common law contract. Karen's the agent, Richard's the principal, and explained that the contract is breached by said explanation and then defenses and explain the damages and such.
Yeah, I would sit up there and say the contract was breached. She breached the fiduciary duty of trust. She breached the implied covenant of good faith and fair dealing. And there's some more. There's some more. I'll show you the others. There's some more that we need to show you. And this, I think this is the last slide. No, that's not it. Your book lists them. It makes a list of them. Duty of loyalty, duty of accounting. You can get them in your book. Duty of accounting. It's not that one. It's not that one. No, I don't see it. But it lists all the duties that you have. Yeah, it's not there. And I'm not, but anyway, there's more than, duty of loyalty, duty of honesty, duty of accounting. No, I was doing so good tonight. I just can't find that one slide. But anyway, they have duties that it's in your book, duties of the principal, duties of the agent. You need to learn those. Duty of loyalty, duty of honesty, duty of compensation. You got to pay the agent. They have a right to revoke the relationship, but it lists all the different duties. And you could argue that many of those duties was breached when she stole that money from him. She didn't give a proper accounting. The duty of notification. An agent's supposed to give you a duty of notification. A lot of times a lawyer will settle a case for $2 million, tell the client he's only settled the case for $1 million. The client is happy to get the $1 million and not know that the attorney has settled the case for $2 million. One way to avoid that is ask to see the insurance check firsthand. But a lot of people get ripped off that way. The agent rips off the owner of the case, which is the client or the owner of those injuries. Otani's agent ripped him off. He gambled with a lot of Otani's money. But if your agent steals money from you and buys things, you can get a constructive trust over those things that they bought and get those things like a boat, car, or airplane transferred back into your name in a court of equity under what's called a constructive trust. You can also sue them for damages in a court of law. You can also avoid what they did by avoidance and have what they did nullified by a court of law. You got to count your money. You got to count your money. There are people out there who will rip you off. Okay. And that's about it. Does anybody have any questions? What time is it? Oh, 10 minutes to 8. Did all that stuff make sense? I know it was a lot at once, but did it make sense?
Yeah, it made sense.
Okay.
There was a few terms that I need to study that caught me off guard, like the fiduciary of trust. I don't have anything on my notes regarding that in previous classes, but I think it just might be in the homework.
Yeah. The fiduciary duty of trust is the highest level of trust you can have. In other words, that tax man should have never referred that old 85-year-old lady to his friend who was a con artist. And he knew he was a con artist. He owed her a fiduciary duty of trust. People who give you legal advice, they owe you a fiduciary duty of trust. They're supposed to look out for your best interest. Your own insurance company is supposed to look out for your best interests because you're paying them. Now, they can treat your adversaries bad. If somebody's suing you, they can treat your adversary bad because they're your insurance company, but they cannot treat you bad. They can't treat you because you're making payments to them. So they have to treat you in good faith. But they can treat the people who are suing you in bad faith because they don't have a contractual relationship with them. But they have a contractual relationship with you, and they have to treat you in good faith.
Now, say for example, I referred you to this law firm or whatever. And when I was working with the law firm, everything went great. But then when you worked with the law firm, they did some type of, so like my intentions were good and I didn't know they were gonna scam.
Right. You would have to know. You would have to know. You would have to have saw him do some shady things before or saw them do some shit. You'd have to be put on notice.
Got it. So if say for example, you then sued me because I referred you to the law firm, I can plead my defense. Well, I didn't know, and everything went great.
Correct. You can say that I did not know they were going to rip him off. I did not know they were going to cheat them. They had been honest the whole time I worked for them. You understand? But this guy knew that his friend had a less than his friend had a terrible reputation for ripping old ladies off and scoundering away with their money. And he knew that, and he still introduced her to her.
Mm.
So that's why that attorney, who I believe was a very smart attorney, sued him and not the con man.
Yeah.
Because he had good insurance, he had a good business. He went after him. You had no business introducing her. He didn't go after the con man. He went after him. Okay. So does anybody else have any questions? Anybody else have anything they want to say? Or anything they would like to discuss? And remember, you guys can always text me if you have questions. You can always text me if you have questions. All right? But other than
well, because I think no, I think I'll ask you next class. There was a question I think in the last quiz that caught me off guard, but I'll review it, and then it hasn't been graded yet, so I don't want to. But I'll ask next class.
Okay. All right. What is it? You don't. Okay.
I have to go back to it. I just remember. I forget which one it was. I don't even know if the question's available for me to see anymore. But.
Okay.
But yeah, I just remember I was like, oh, it was kind of like a head scratcher. I had to really think about it. I forget which one it was.
Okay. Oh, here. This. I already went over this one with you guys. No, it's not that. Okay. When you think of it, don't hesitate to ask me. Okay.
Okay. Thank you.
All right. That's it. Oh, thanks for that advice on the bank. They gave me my money back.
Oh, nice. Glad to hear. Yeah, because they have to at least give you a provisional credit within 10.
And that's exactly what they did. They gave me a provisional credit.
Okay, good.
Okay, so how much I owe you? Send me a bill. Send me an invoice.
No, that's just my my duty as a credit union.
You're living up to your fiduciary duty of trust.
Exactly.
All right, but even though I don't have a bank account at your bank.
Yeah.
Yeah, you don't owe me a fiduciary duty of trust. All right, you guys. See you later. Bye, Malik. Bye, Angel. Bye, Ileana.
All right, good night.
You guys have a nice one. Good night.